There we go. Just to know that you're being recorded, so that, or rather I'm being recorded, so that if any of your colleagues miss this session or anybody wants to listen back to it, we'll send the link through to that subsequently. Next slide, please. So the recording will be made available, and as Molly said, if you've got any questions as we go along on the dispute resolution process, then please do pop those into the chat, into the Q&A function. So what we're looking at today, you'll probably be very familiar now with the idea that the new Who Pays guidance, the 2020 guidance, has a mandatory dispute resolution process. So this is one of the new things that's come along in the 2020 guidance, alongside the new rules on discharge to assess, hospitals, CHC, section 117. But the dispute resolution is really sort of flagged up for you and writ large, because this is something we haven't really had before. What did the 2013, which was the last guidance, have to say about disputes? Well, actually very, very little about what CCG should do when they find themselves in disagreement about who should fund a particular kind of placement. I've taken the quotation on the slide there from paragraphs 7 to 9 of the old Who Pays guidance. It started out, as this one does, saying the safety and well-being of patients is paramount. It should never be jeopardised by squabbles between commissioners. You can see from that quote there, it was very much everybody was supposed to act in the best interest of patients, work together in a spirit of partnership, come up with pragmatic solutions. I think pragmatic solutions were probably in short supply, as a matter of fact, because I'm sure you'll all appreciate that when you've got two sides each fighting their own corner and arguing very strongly that their interpretation of the law and the guidance is correct, people can become extremely entrenched in their positions. So any sort of compromise tended to be rather off the table, I think. Cases that couldn't be resolved at CCG level were supposed to be sort of referred up, or advice obtained from the area teams of NHS England. And I don't know how much of that really went on and how much formal arbitration. I think it was all very sort of haze and jays and let's make it up as we go along, and everybody standing on the sidelines and sort of sighing because these disputes simply never got resolved. Next slide, please. So what have we got this time? Now we've actually got a proper process in place. So if you look at Appendix 1 of the new Who Pays guidance, that's where you'll find the bulk of the material about the new dispute resolution process. It's a three-step process, and the formal arbitration step comes as the third step. And Appendix 4 provides you with some template Word documents for use there, so that everybody's going to be providing the same documents through to the process. And it's all very clear, you know, nobody's going to be doing some sort of bespoke and random off the wall thing. You know, this is the guideline, this is the template, this is what you will use. It became effective on the 1st of September. Participation is mandatory. So you can't simply choose whether you're going to oblige anybody or not. You must comply with this process. If you fail to cooperate, and the matter does go to step 3, which is formal arbitration, NHS England can, and it emphasises this will be exceptional, but NHS England can take into account your failure to cooperate. So basically, you know, the message is very clear: toe the line. The outcome is binding on the parties. They are expected to implement it. Now, the dispute resolution process will not assist you if there's a dispute between the CCG and the local authority about who's going to be funding. This is CCG to CCG and CCG to NHS England. So it's NHS commissioners only, and it's NHS commissioners in England only. So if you have cross-border disputes, those are still going to have to be subject to the best process you could find, arguing, submitting, and possibly taking the matter to court. Nobody wants to do that. And that's largely why NHS England has put this mandatory process in place. You'll all have seen case law, things like the St Helens case in the field of CHC, where judges have gone on and on about how very, very unpleasant it is to see public bodies in court spending public monies, having a spat in public. You know, it's deemed to be very, very unseemly. Sometimes there is no other option, but it is looked upon very, very negatively. One thing that's made very, very clear here is that the new 2020 guidance does not apply retrospectively. So you shouldn't now be taking the new rules and the new process and using it to unpick funding arrangements that are done and dusted. That's just going to be expensive, it's going to be difficult, and you don't need me to tell you that there are things that are far more deserving of your attention and focus at the moment. However, what NHS England has said is that in any area where the rules are not new, so that's not hospital stays, discharge to assess, and all the other things I've mentioned there on the slide, then the new who pays is supposed to tally with the old who pays. I mean, I think given that pretty much every contentious area is listed in the not category there, you're going to be working from the new guidance, start afresh, look afresh. If you've got a dispute that is still running from pre-September, then it is capable of resolution through this process. Next slide, please. Right. So the first step of the process in Appendix 1, as I've said before, it's a three-step process. Step 1 is local resolution. And anybody here who's had the joy of engaging in a judicial review piece of litigation will recognise the idea that you are supposed to have exhausted all your local remedies first. So this is your last-ditch stand by the time you get to formal arbitration. So step 1 is local resolution. And you should, the CCGs that are in dispute, or CCGs and NHS England, I'm going to focus primarily on CCGs in dispute today, you should attempt to resolve the matter locally first. Now, if you need guidance to do that, because obviously if you've got two CCGs, each believing they're correct, then you're just going to be butting heads and not really making any progress. So the idea is that you should seek some sort of guidance, and you should do that jointly between those two disputing CCGs. If you are all within one integrated care system or STP, then you can seek advice within that system or partnership. Another idea that they've put forward is that you can seek advice from relevant officers in NHS England regional teams. So that might be regional leads for CHC or regional leads for the Transforming Care agenda. Another alternative is that you email the NHS England what they're calling the National Team for Responsible Commissioner Disputes, and that's pretty much a team that's headed up by Alistair Hill. They're quite happy to receive your queries on that email address, england.responsiblecommissioner@nhs.net. And before you activate the formal dispute resolution, you've got to have escalated your local resolution to director level. Next slide, please. So what should happen as regards funding while you're working through this process? Where you're not making any headway swiftly at local level, the patient's care is going to suffer if somebody doesn't step up to the plate, basically. So the new rule is that the two CCGs have to agree which of them is going to press on and make those commissioning arrangements. So the commissioning arrangements now are actually, securing the patient's care, entering into the contract. One of you must go, I'm going to do that. I'm going to make the arrangements for the patient to be assessed, and then I'm going to ensure that the necessary care and treatment is put in place. The cost of that, even though only one CCG is taking the lead and getting ahead and organising it, the cost is going to be borne equally between the disputing CCGs on a without prejudice basis. So once you've got to a final step in resolution, or you've gone through mandatory arbitration, then the appropriate financial reimbursement will be made by the party that's found to be ultimately responsible to the party that put up their 50% of the funding on a without prejudice basis. So clearly underlining the central rules there, no delay to patient care, and the provider must be paid promptly, because you get providers who are still waiting for invoices to be paid 2 years down the line. They've provided the care to the patient, so it's not really fair that they're not being paid just because the CCGs can't decide which of them is responsible. Next slide, please. So moving towards stage 2, and this is where I have to say the new guidance does lose a little bit of clarity here, because it talks again about resolution at system or partnership level, and it's not altogether clear how that is distinguished from step 1. My interpretation is that step 1 is CCGs are the boxers in the ring, if you like, and they're just going out to the ICS or the STP saying, can you give us some guidance that we, the CCGs, can implement? By the time we get to step 2, then the wording is a little bit vague. The dispute must be sought to be resolved at system level with input from. Now, I think we already thought we'd had input from the ICS or STP leadership by them providing guidance to us at step 1. So whether this is a slightly more formal escalation to the leaders within the ICS or the STP, it's just not really very clear, I'm afraid. The wording used there is as appropriate, but nobody's actually saying what is appropriate. So my interpretation is step 1, CCGs seek guidance. Step 2, CCGs almost refer up to the ICS or the STP leaders. And it's a little bit more, can you get involved and throw some weight around, perhaps? If the disputes between CCGs within different ICSs or STPs, then the guidance just says that the 2 ICSs and STPs should liaise to seek an agreed resolution where that's possible. So it's all, you can see this now, this is very much using the more sort of collaborative, cooperative, integrated footprint that the 10-year plan's talking about. So the guidance is recognising that we are moving forward in that direction. So next slide, please. So finally, step 3 of the process, and this is the formal arbitration process. So if you've worked through the first 2 steps trying to secure local resolution and that hasn't succeeded, there is now an absolutely formal process you must go through. So working together, the 2 CCGs, I'm saying 2, it may on occasion be more than that, but I'm just going to say 2 CCGs in a dispute here for simplicity. So you should work together to work up a single agreed factual chronology, and you must redact patient identifying data. There must be absolutely nothing in there that will identify the patient. I can't emphasize that strongly enough. So you submit that chronology to that email address, responsible commissioner, NHS England @nhs.net, that's on the previous slide. And you say, dear national team, please can you arbitrate? This is our agreed chronology. Now, Appendix 4, as I said, has these Word template documents that you can use, and you'll find a sample chronology there. It's very clear how that's supposed to be completed. When you submit it to that NHS England address, make sure that senior representatives of all of the parties involved are copied in. Your chronology should make clear if the entire period is in dispute or if there's just a very particular time span that's in disagreement. And it must provide all relevant background, including is the word that's used, so not necessarily limited to these things, but these are the minimum things you must cover off. So placement, where was the patient treated? What dates did they go in? What dates were they discharged? What circumstances? Make it very clear. You know, are you looking for who is the responsible commissioner for a period of 117 aftercare? Are you looking for who is the responsible commissioner for a period of CHC? Are you looking at D2A? Be very, very clear. And you may be looking for more than one type of care, one different type of period. And if so, make that clear. Who's arranged the patient treatment to date? Who has funded it? And absolutely critically, and what I've always said to clients, they'll be used to me banging on about all of these things when they've come to me for responsible commissioner advice. They need a history of GP registration and also where the patient has been resident. So in this case, we're looking at usual or normal or just factual residents. Where were they living? Next slide, please. Right, so NHS England have then received your chronology. They may have some questions on it. In that case, they will come back to you and ask for clarification. Once everybody is happy that there is as complete a chronology as you're going to be able to get, the national team will say, can we have your statements of case, please? And although the chronology was agreed and joint, because if you can't agree the chronology and you can't agree what's happened factually, nobody's going to be able to make any headway. But at this point, the road separates and you each submit a separate statement of case. And in this, you're going to be referring to the necessary legislation. So that might be the NHS Act 2006. It might be the Responsibilities and Standing Rules Regulations 2012. Might be the Disapplication Regulations 2013. Whatever it is, make it clear which piece of legislation you're referring to. And it says any guidance, including who pays. So if you find any other guidance that you feel might be relevant, cite that as well. But broadly speaking and essentially refer to which bit of who pays you're relying on. And just set out why you say you are not the responsible commissioner and why the other party is. Templates are available in Appendix 4 for your statement of case, and this, you know, it's not exactly a sample there, but it's got very clear headings of what should go where. So this is a sort of a quasi-legal document. You'll have seen these sorts of things in different forms before, and I think particularly probably in court of protection sort of things, court of protection statements, position statements. So it's really, it doesn't need to be drafted by a lawyer. You may want to get some guidance on how to do it, get somebody to overlook your final version. But the idea is that you should be able to do this yourselves with the guidance that's in the template. So it's clarity, comprehensiveness, and just making it extremely clear which bits of legislation and guidance you think apply. Now, once they've received a statement of case from each CCG, the national team at NHS England may request further information from you. And this is, as I said before, cooperation is expected. You know, this is not something to sit on. This is not something to think you can just turn a blind eye to. You know, if you're asked for further information, provide it. And if you can't provide it because it doesn't exist, then explain that. So the national team's then got all the documentation that it requires to reach a conclusion, and it will produce what it describes as a brief arbitration report for the parties. Not sure what brief means. Presumably it means it's not going to go on for 40 pages. Is brief 1 page, 2 page, 5 pages, 10 pages? I don't know. I haven't seen one of these yet. So, in fact, I've only had one case that's been referred, and that was actually referred by a local authority that was seeking some sort of guidance, and I'll just come back briefly to that at the end. So, you know, local authority gets fed up with 2 CCGs, going 3 CCGs, each going, not us. And so they can then sort of basically dob you into NHS England and say, we're rather tired of this, please exercise a little bit of leverage and get the CCGs to play ball. So that arbitration report will come back from NHS England, and it will basically say which body is responsible for commissioning, that's making the arrangements, and which body is responsible for funding the services during the disputed period. Because that, as you'll recall from our previous sessions, is a touchstone of the new guidance. They've been very, very clear in setting out that the party that makes the arrangements and enters into the contracts is doing the commissioning, and the party that pays is doing the funding. And there's a very clear split between those two things. So the commissioning rules are set out in law, and payment rules are set out in this 2020 version of Who Pays. The arbitration report is binding on the parties, and you are expected to implement it. And they reckon that unless they are absolutely overwhelmed with cases, and nobody really has any feel for the number of cases that are going through this new system, just because we haven't had it in place long enough, but they're anticipating the whole thing will take them around 8 weeks from submission of the statements of case. Next slide, please. So you might ask yourself, how much is all of this going to cost us? Well, NHS England have said that assuming the volume is manageable and that they can deal with it all in-house, there will be no charge for their arbitration service. There are 3 exceptions to that. They've said that if it's a particularly complicated case, and I can hear you all jumping up and down and going, which isn't a complicated case when it comes to a responsible commissioner dispute, but they've said if it's exceptionally complex and they don't feel they can deal with it in-house, they will seek external legal advice. And the cost of that advice will be recharged to the disputing parties 50-50, or if it's 3 of you, a third each. Now, if it's a CCG and NHS England dispute, who should be funding? Perhaps there's been an element of specialised services in there somewhere. Somebody's not entirely clear whether NHS England should have been funding, whether it should have reverted to a CCG. If the CCG objects to NHS England conducting the arbitration because it feels it's going to be judge and jury in its own cause, then NHS England can instruct an independent firm of solicitors to conduct the arbitration. So that's not providing advice, that's actually conducting the whole thing, the whole arbitration process. And again, the cost will be recharged to the disputing parties. So that will be NHS England and the CCG this time. And again, even split, 50-50. If the volume of disputed cases absolutely outstrips all capacity, then they've said that we reserve the right to outsource the whole thing. Kit and caboodle will go out to external lawyers, and the cost will be recharged to the CCGs, again, splitting the costs evenly. Because each of you is benefiting. This isn't one of those things that works like court litigation where the loser pays the winner's costs. This is very much got this undertow of cooperation behind it. It's not a winner and a loser situation. Next slide, please. So just a couple of points finally to remember here. Disputes, they've said, must be initiated promptly. I mean, inevitably, you're going to try and sort it out between the parties themselves to begin with, the CCGs. Then you're going to go through those initial stages of trying to resolve the matter on an informal basis. Then you're going to escalate it. But they've basically said that the maximum retrospective financial adjustment, which will be made after you have an arbitration report from NHS England saying this is the responsible commissioner, the maximum adjustment will be to the beginning of the financial year in which the dispute was formally initiated. Now, it doesn't define formally initiated, but I'm assuming formally initiated is when you've actually triggered step 3. So that's when you're going with your chronology and your statements of case. So if that occurs, say, in June 2021, then the maximum reimbursement over the disputed period will be to the beginning of the financial year, beginning in April 2021. So the whole thing is geared towards getting this done fairly swiftly, efficiently, trimming back costs. point I just referred to very briefly on the previous slide is that if a third party, so either a local authority that's in dispute with a couple of CCGs, or a provider who's been unpaid for a couple of years, if they're having a struggle getting a CCG to say that they're responsible, they can refer the matter to the national team. So they can drop an email to NHS England at that address and just say, you know, we're not making any headway, we've tried everything, we've explored all options. Can you basically get everybody to see some sense and, you know, apply a bit of pressure? And it's in the spirit, the whole thing here is in the spirit of driving matters forward, not letting everything sit on the back burner and trying to get these disputes resolved. So that is a very, very quick trot through the new process. I hope you found that helpful. I've tried to make the slides reasonably comprehensive. They will be circulated afterwards within a couple of days or so that you have that and the recording to look back on if you find that helpful. Next slide. If anybody has any questions, Molly will come in just a moment and tell me if there have been any questions that have been put in the Q&A session. She's smiling at me in a very peculiar way, which either means there's absolutely no questions at all because you all how this is going to work beautifully, or it means somebody's put a real stinger in there for me. So Molly.
Well, luckily for you, Jane, I think you have been so comprehensive with that there are currently no questions.
No questions, my goodness, must be a first. But if we just rattle through the next couple of slides, Claire, thank you. Feedback. A feedback form will just pop up for completion when you complete this webinar. I know you've all got to rush off to the day job, but if you can just spare us a couple of minutes just to fill that in, that is extremely helpful for us in terms of how we did today. Did you think that satisfied your requirements? Did it help you going forward? And also if you just drop us a line on any other topics that you'd like to hear about. Final slide. Those are my contact details. If you do think of anything later in the day that just sort of whipped out of your mind at 10:32 in the morning, please drop me an email and I'll do my best to answer your questions on the new dispute resolution process. Otherwise, final slide. Thank you very much indeed for your time this morning. If you've got any questions or you'd like to speak to one of us, those are Jill Mason's contact details and she heads up the health and care team at Mills and Reeve. So thank you very much.